All right, and then the next case, People v. Page, I did sign a remand order to the district court, so that's taken off the docket. And Mr. Clayton, that would bring us to People v. Jason McCumbee. And that's filed 25-6976FH.
Judge, can I approach real briefly?
Sure.
I just for the record, I'm handing the court. I just showed Mr. Goodrich. I'm just wanting to hand the court a few things Mr. McCumbee brought me today. I apologize for not having copies. I can make copies to make them part of the court file. But just for purposes of identification, I'm just simply going to hand the court some completion, some coursework he's done, and some AA that he's done, just to kind of demonstrate to the court what he's been working on.
Very good. Thank you. All right, so Mr. Clayton, we're here for sentencing on in OWI third.
Yes, sir.
And an attempt RNO, statutory maximums at 5 years and 1 year, guideline range at 0 to 6 months. Any additions, corrections, or scoring challenges from the defense?
No, sir.
Ms. Goodrich from the people?
No, Your Honor.
Mr. Clayton, go ahead with any, I have a requested forfeiture order from the prosecuting attorney. Does the defense have any objections to that?
We do not.
Okay, so we'll go ahead and sign that.
I thought we'd already signed the stipulated order, but I signed a lot of things every day. So I thought I had, but we discussed it. No, that's fine.
Okay, so I've signed that. Do you want me to give that to the clerk or turn that back to you, Mr. Rich? I don't remember.
I believe it goes to the clerk.
Okay. All right, Mr. Clayton, anything you want to say on behalf of the client?
Sorry, thank you, Honor. You know, I was trying to think about how I wanted to address the court on this. I've been in front of you a lot of times. You know that I try to look at both sides of the argument and try to anticipate what the other side's argument is going to be. And I completely understand. I think it's essential as an attorney to understand what the opposing side is. You know, so Ms. Goodrich and we talk a lot about our cases, and I understand that to a certain extent, to a large extent, she serves a different master. She's got a different job than mine, and that's how an adversarial system works, and that's fine. But we don't have to agree, and a lot of times we don't agree, but I can respect other opinions. What I want to share with the court today is my acknowledgement of the downside of Mr. McCumbee, the positives that he's making, and then the difficult balancing test this court's going to have to make. I think it is a difficult balancing test. And normally I wouldn't say, well, Jesus, a tough balancing test on a 0 to 6 guideline because they're going to be a sanction. How tough can it be?
No,
But
you're right, because my question in my mind was whether we should send him to prison or not, despite the guidelines.
Right.
So yeah, you're right.
I mean, it's tough. It's tough, you know. And when the analysis is being done, I think it's important to look at. And I think I go back to the basics. What's the 4 goals of sentencing? You know, we all know them. It's, you know, it's not novel legal argument. You know, when I look at drunk driving cases, in my opinion, probably the biggest goal is protection of society, 100%. You know, because we get to all use the same roads. Why should I be in any kind of danger? Why should my family be in danger if somebody makes a decision to inhale chemical dust and drive a car? Why should that come on me? You know, but I also recognize that that's only one small aspect. The other aspect we consider is rehabilitative efforts, punishment, obviously, and deterrent effect to others. I tend to think that the deterrent effect to others doesn't really have a lot of impact. The reason being is that most people, if they saw the minimum sentence that the court is required to give of 30 days, that'd be a deterrent effect to anybody. Nobody wants to sit 30 days in jail. Nobody wants to sit 6 months in jail. Nobody wants to sit 18 months in prison. But I think there's a diminishing marginal return when it comes to how much time. What's that number? Okay. So when I look at drunk drivings, and I represent a lot of people accused of drunk driving, a lot of people convicted of drunk drivings, I think that probably the most important thing, they go hand in hand. I think it really does. The rehabilitative efforts of the court and the protection of society, how those marry, how do they merge? What's one trumps the other one? And I don't think in this case they need to. I don't think there is one trumping the other. I reflect back, and you know, this case has been going on for a while. Mr. McCumbee has made a lot of progress.
This is a pivotal moment. The defense attorney lays out one of the most important frameworks in criminal court, the 4 goals of sentencing. This is where legal strategy meets moral judgment. In OWI cases, the tension is always the same: protecting the public versus rehabilitating the individual. The defense doesn't deny the danger. Instead, he reframes the story around growth and accountability. That raises the real question for viewers. Should demonstrated progress matter more than repeated failure? If relapse keeps happening, does that automatically mean prison, or can strict, closely monitored probation still protect the community? Put yourself in the judge's seat. What would you decide?
Progress. But I remember I was leaving last year on vacation, and as I was leaving, I got a phone call from Jason, and I've been trying to talk to him and say, hey, listen, when are we gonna get serious about this? When are we get serious about, your recovery? You've been through the sobriety court, you've been through treatment before. When's the light bulb gonna come on? And I had this conversation, Jason will remember this, with him many times. And he called me up, kind of out of the blue. He said, I'm ready. He said, I'm ready right now. He said, I've got a bed, Sunrise Center. I've got a plan. I'm gonna be there for a long time. The court, remember, for a long time, when we did the hearings of Mr. McCombie's case, he was doing it from the inpatient treatment. And I think there was a little bit of guarded, maybe a skepticism. Is he going to stay? Will he actually follow through this time? But almost like clockwork, we do a jury status conference. Here's Jason at the center. Do another status conference. Here's Jason still at the center. Then he gets out. What's he doing now? He's doing his outpatient counseling through Harbor Hall here in Sheboygan. He's going to meetings. He's going to do everything he can to make himself a better person. All of that leads me to believe that there is great rehabilitative hope right now for Mr. McCombie. If he's rehabilitated, if he doesn't use drugs, if he doesn't inhale chemical duster, if he doesn't drink, everybody's safe. He's safe. He lives a long, happy life. We're safe because we use the roads that he uses when he gets a license. Everybody's better off. The alternative is, and this is where I think the tough decision for a court is the court would very justifiably say, well, I know how to make society safe for at least the next 18 months, 100%. If he's sitting in the Michigan Department of Corrections, guess where he's not? He's not in a car driving around killing somebody. And that's a good argument. But that doesn't solve the problem. Because the problem doesn't occur until or if Mr. McCombie decides that he no longer wants to be sober. And that's why I think a probationary sentence with monitoring in the community makes a lot of sense. If he's to fail, he'll fail in the next 2 years. If he's to really succeed and get cemented in sobriety, that'll also happen in the next 2 years. If the court sends to the Michigan Department of Corrections, it solves Sheboygan County's problems for a while, but not forever. Now, potentially, he could go to the Michigan Department of Corrections, and he could get counseling there, and he could stay on a good track. But I think the better option, in my opinion, is to let him stay in the community, let him stay doing what he's doing. Now, I know there's gonna be a break in it. There has to be a break because he has to go to jail. There's no scenario today where I can make it an argument, a colorable argument that's consistent with the law to say he doesn't go to jail, because he does. It's just for how long. And the guidelines 0 to 6, advisory only, post Lockridge. The guidelines are a tool, but I think really, and I know you do this, Judge. I really do. I know you weigh these decisions because you have another master serve. You have the people who live in this community, who live in all these communities. You preside over court of general jurisdiction. Your responsibility is everybody in the state of Michigan to keep them as safe as possible. I'm asking you to.
As the judge addresses the defendant, the weight of this case becomes undeniable. Years of treatment, relapse, hope, and risk all collide in a single moment. This is the reality of sentencing. It's not just punishment, it's a gamble on a person's future. The defense asks the court to believe in change. The prosecution points to patterns and danger. And the judge must balance public safety against the possibility of redemption. Whatever the final sentence, this case exposes the ongoing struggle courts face when addiction, relapse, and community safety intersect. If this case left you conflicted, hit like, Share your thoughts in the comments and subscribe for more intense, real-world courtroom breakdowns you won't forget.